Meeting to order. Katie, please collect roll.
Mrs. Sealing? Here. Mr. Hoffman?
Here.
Mr. Wimble?
Here.
Mr. Updike?
Here.
Mrs. Mitchell? Here. And Mr. Anderson?
First item on our agenda is approval of the agenda.
So moved.
Second.
It's moved and seconded for the approval of the agenda. Katie, please collect the vote.
Mr. Hoffman?
Here. Yes. Sorry.
Mr. Wimble?
Yes.
Mr. Updike?
Yes.
Mrs. Mitchell?
Yes.
Mr. Anderson?
Yes.
And Mrs. Sealing? Yes.
Please rise and join me in the Pledge of Allegiance. I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Moving on to our agenda item, our discussion item. It is the district legal counsel to present updated additional information regarding the Johnson County mandate order in K through 12 schools. Mr. Goheen.
Nice to see everybody this evening.
Good to see you. Thank you.
I wanted to sort of start off by saying a couple of things. One is that I want to make sure everybody understands what my role in this entire process is and what my role is not in this entire process. I am not a board member. I am just here to give you guys legal advice and to try to answer questions based upon the laws and the information that I can ascertain and give direction as to what may or may not happen based upon that advice, and to give you guys guidance so that you can make informed decisions about whatever policies that the district wants to follow or adopt. And ultimately, my responsibility also is to defend the board's actions, which I will do as long as they are not illegal in some capacity, which I don't believe that there's any action that this board would take that would be illegal one way or the other, nor do I think that no matter how the board moves in this direction, that's what's going to happen. So I say that because part of that, given that legal advice, involves things such as attorney-client privilege and work product. And obviously the board has the opportunity, should they choose to do so, to go into executive session to hear that advice. Otherwise, that advice is waived. But if nobody moves to go into an executive session, I'll answer questions and provide that information as though the board is directing me to do so rather than individuals, because I don't want to inadvertently waive any attorney-client privilege that the board as a whole may wish to invoke. So I'm just saying that at the front end, so that if there's any point in time where the board as a whole believes they want to hear some advice or some piece of information in confidence that would retain that attorney-client privilege, they know how to do that. Okay. So having said that, when we left our last board meeting, there were several questions that the board had asked me to look into in connection with the issue that relates to the public health order issued by the county. And I have endeavored to do that to the best of my ability, and I'll kind of wander through some of those things. I did want to point out that in addition to conducting my own further research on what the board could do in terms of trying to elect to do an opt-out, what a resolution would look like if the board wants to try to exercise some degree of authority to try to opt out or avoid application of the Johnson County Public Health Order, what that might look like, what that procedure might look like, what that resolution that would be required might look like in that regard. I also went back through what the potential consequences or concerns that I had about any decision to not follow the order and what impact that might have on the district, as well as the district's employees, and have tried to convey that information. As the board is aware, I've provided some of that in the context of a formal work product and privileged email to the board members. I'm going to discuss some of those topics here tonight, and certainly will answer questions related to that. In addition, I also reached out to the Kansas Association of School Boards, which is an entity which this district is a member of. They also provide legal advice to member school districts. I asked them to weigh in and provide an opinion as well, which they did this afternoon, and I forwarded that to the board as well, although it was late because I was in another board meeting before I had to come to this one. And finally, I also was able to reach out and talk to the county counselor for Johnson County earlier today. And I provided some indication of the information she's provided to me in terms of what she is indicating the county's position is right now. I did not get anything in writing from her, but I will at least convey and walk through what she told me and what information she provided to me. So kind of with that in mind, sort of the starting point is what I understood the board's first sort of concern, for lack of a better word, was exactly what is home rule and to what extent does the school district have any kind of home rule authority to act or to depart from statutory or other laws passed by other entities, other governmental entities, whether that's a city, a county, public health board, another school district, the state itself. And so home rule, just again, as a premise, home rule is not really it's more of a concept than it is anything that is definitive, like you would look it up in the dictionary and it would have a specific definition. But essentially, home rule is the notion that local governmental entities can be created by the state, very similar to in two different ways. One, they can be developed and authorized by the state legislature with specific restricted powers. In other words, I could say, I'm going to create a local governmental entity, and the only thing this governmental entity can do is they can construct water pipes to connect fresh water to city residents, and they can't take any other act. That's the only thing they can do. And that's a prescriptive delegation of power, delegation of state power to that local governmental entity. And so that entity has no authority or ability to depart from the limited scope of authority granted to it by the state. The courts have sort of colloquially called that the Dillon rule, and the Dillon rule is based upon a case out of, I think it was Illinois or Iowa, that was sort of the start of that sort of concept. The other thing a state can do is they can create local governmental entities that have broader scopes of power. In other words, that scope of power is only limited by specific things that the state says. So for example, the state can create a city, and they can say the city is created as a local governmental entity, and the city can do anything that any entity under law could do, except that the city can't do X, Y, Z. So the legislature could put limitations on it, but otherwise that city has self-governance authority subject to any statute that is imposed upon the city under a specific statutory provision or enactment. And that's called colloquially home rule. So home rule means the power that's reserved to the local governmental entity to act. You could kind of think of it in the sense that the Bill of Rights in the US Constitution, where there's a specific grant of power to the government, and then all other powers are reserved to the state. So it's that type of concept. So in Kansas, at least, there are different ways that home rule exists. Home rule was first allowed or granted in the state of Kansas back in 1961. It was granted to cities, municipal governments only. And that was by constitutional amendment back in 1961. And then there was a subsequent legislative statute that was passed, which is found at KSA 12-101 and some other laws that follow that. And so sort of based upon that power that cities have, they have the largest degree or measure of self-government of any type of local government in the state of Kansas because it's constitutionally derived, and cities can exempt themselves from state laws that are uniformly applicable to all cities. The only thing they can't exempt themselves from are state laws that are specifically directed at that city or that size of city by the state. So there has to be a specific statutory enactment that says, hey, city of Spring Hill, you cannot do this. And that cannot be exempted from home rule. There's some other statutes that will say you can't exempt yourself from home rule. For example, the waiver of immunity under the Kansas Tort Claims Act is a statute by the state of Kansas that said, and it specifically says in it that no local government can exempt themselves from home by use of home rule from application of the Kansas Tort Claims Act. So that's an example for you of what that looks like. So the next sort of entity that's out there that has some degree of home rule are counties. And unlike counties, there is no constitutional amendment under the Kansas Constitution that deals with home rule or authority under the home rule concept under the Kansas Constitution. There was an attempt to add counties to the Kansas Constitution, and that died back in the 70s. And so the only home rule authority that the counties have is by statute. And so the big key or issue there is, because it's statutorily created instead of constitutionally created, that the home rule powers of, or the governing powers of a county can be prescribed more readily by a statute enacted by the legislature. Legislature merely has to impose an additional restriction. And then if that happens, the county has less authority than they did the day before. The same thing, by the same token, the state can increase the county's authority by statutory enactment. And in fact, if they wanted to, could take the home rule authority away completely by statutory enactment if they chose to do so. So the real question, I think, for the school board is, so what does that mean for school districts? Sort of where do we fall on the spectrum? And there's two sort of grants of power to the Kansas public school districts. Unlike counties, school districts are called for in the Kansas Constitution, and they have a provision in the Constitution that provides for powers and authority granted specifically to school districts. However, in that legislative or that constitutional grant of power, the power is limited to some degrees by the State Board of Education and also by legislative enactment. And so the court's looking at that, particularly in the school finance case. That's where most of the litigation is that relates to schools, has said that the constitution of power of a school district is not self-effectuating. In other words, it still relies to some degree on a legislative action, a statute, to give that power to the school districts. And so when you hear people talk about home rule power or limited home rule power of a school district, what they're really talking about is a statute that was enacted by the legislature. I think it was back in the early 2000s that modified how school districts get their power to govern, frankly. And that's KSA 72-1138. It previously had a different statutory site, but that's the new number for it. And some of this was already in place, but it basically says that the board shall have and may exercise the same powers and authorities that were available prior to this act conferred upon school boards of education. And that power is expressly, and any other power expressly conferred by law. And so that includes things like the power to sue and be sued, the power to enter into contracts, to buy land, to do things like that. So there are specific grants of power authority for school districts to do those types of things. It also provides in there, and this is the broad one, or one of the broader ones, and that is the board shall have the authority to prescribe courses of study for each school year, to adopt rules and regulations for teaching in the school and general government thereof, and to approve and adopt suitable textbooks, study materials for use therein, subject to the plans, methods, rules, and regulations of the State Board of Education. So in other words, there's yet another grant of power limited to some degree by the State Board of Education. Finally, and this is the one that was kind of added that really broadens the school district's authority and is what everybody cites to when they look at what the home rule authority is. The board may transact all school district business and adopt policies that the board deems appropriate to perform the constitutional duty to maintain, develop, and operate local schools. And that's in KSA 72-1138E1. However, this third part of this grant of power is not completely unlimited. And it says that power cannot be construed to relieve a local board or a board of education from compliance with state law. So you're still bound by state laws. That power granted by this subsection cannot be construed to relieve any other unit of government of its duties and responsibilities that are prescribed by law, nor create any responsibility on the part of a school district to assume the duties or responsibilities that are required of any other unit of government. And unlike other actions that can be taken by a school district, and this gets into the process, if you were to decide you want to take some action to attempt to invoke this statutory provision to depart from the order given by the Johnson County Board of Health or Public Health Board of Health, it has to be by resolution of the board rather than by motion. So as you guys are well familiar, most of the time the school district by statute can either take action at a public meeting by motion second, roll call vote or a vote. If the motion passes by a vote of 4 board members, which is the majority of the board, then the motion passes. If it gets less than 4 votes, it fails. So you can do most activities by action. As you're probably also aware that there are certain statutes that require the board to act by resolution. For example, the publication of the budget requires a resolution. There are other specific statutes that require certain things to be done by a resolution. And this is one of them. If you want to exercise authority under this specific statutory provision, you have to adopt a resolution. Now, unlike the budget resolution, for example, the statute does not define what is meant by the term resolution. It doesn't provide any requirements as to content. It doesn't require any contents as to form, other than, again, you still have to do it at a public meeting. It has to be convened for that purpose. And it has to be something that you then adopt by the board. It has to be a separate document from the minutes. So you have the resolution reflected in the minutes, but you still have a separate resolution document that is then kept by the clerk. And I believe the resolution has to be attested by the clerk as to the vote. So what does that mean? And to give you kind of an example of what a resolution looks like, the county's order is a resolution. Resolutions typically look like, and again, you guys know this from resolutions you've adopted in the past, they typically start with a naming of the resolution to be enacted by the Board of Education. And then you usually list off a series of what are called whereas clauses, which essentially are factual or legal findings that the board is making as a governing body to support the decision that it's making in the resolution. So using the county's order as an example, the county went through a series of whereas clauses. Some of those included citations to statutes or to legal authority. Some of them cited to studies or informational reports or other factual information that have been presented to the County Board of Health. And then based upon those whereas clauses, you see the sentence that goes after that says is now therefore, and then the county adopts the following resolution and they list off what they're doing as a response to that. So ultimately, if this board decides it wants to try to do something underneath that statutory authority, then the board would create a resolution with whereas clauses that would support the resolution that the board wants to take, and then have the action item in that resolution. And that then would be what the board could do under the statute, and that would be the requirement or obligation to it. I think last time, and I think this was in response to Mr. Anderson's question, if I'm correct, it may have been a different board member. Are there any other processes required? And the answer is no, there don't appear to be. I had wondered whether or not a public hearing would be required or publication in the paper would be required, because for a city to use home rule power under the Constitution, they have to do those things. They have to do a publication and they have to do a formal public hearing. You guys have to do that for a resolution that would support your budget. And so I didn't know, and I hadn't had a chance to look at that, but there does not appear to be a publication or a public hearing requirement. That doesn't mean you couldn't do those things. It just means it doesn't appear to be required by the statute. So that's kind of the lay of the how. The bigger question, or I suppose the next question is, if the school district were to seek to use this authority, could it use it effectively to opt out from the county's public health order, or to essentially try to negate that county public health order, at least as it relates to the school district? And I will tell you from the gate, there is no authority one way or the other that says whether the county's order would be superior to a order issued or resolution adopted by this board, or vice versa. It doesn't exist, at least not that I can find, not that the county counselor can find. And so that answer would not be, I can't answer that question for you. But I can tell you that there are differing opinions on what that would look like, and they all come down to the real issue being, does the county's order as entered or issued fall within the purview of a specific statutory grant of authority that essentially forecloses the school district's authority to act in that capacity? So for example, the county is specifically the entity authorized by state statute to declare a local, I'm going to call it the wrong thing, but local state of emergency, basically. They are the public health officer of the county. So the school district could not, using that statute, usurp the authority or power of the health authority to declare a public emergency. You guys could probably declare an emergency for the school district if a tornado hit one of your buildings or something like that, but you don't have the authority to declare a state of emergency like the county does, because the county specifically has that under statute, and the grant of authority you have under your statute specifically says you don't get to usurp the authority of another local entity to enact your power. So that's just an example of what the courts might take a look at if they had to look at this thing. As I indicated in the start of my conversation, I did ask for KSB to weigh in. KSB's opinion is that, and I'm paraphrasing it to some degree, is that the school district would not have the authority to overturn the county's order based on that statute. That's their opinion. I think it's an open question. I think a lot of it depends upon what we interpret the county's order to mean and what action that the board takes as part of its resolution. Certainly, you could adopt a resolution that would exceed what the county has authorized by clearly under state law, in the absence of any order issued by the county. This Board of Education could decide to adopt whatever mitigation protocols it wanted to do in the schools to deal with COVID or any other outbreak of illness or any other issue in your school district. Frankly, if you wanted to require masks as part of a uniform, you could do that. I'm not suggesting that you would ever do that, but that's the kind of authority you guys have in terms of governing the operations in the school district, just like you would for any other policy that you could adopt directing behavior or conduct within the school buildings. And obviously that would be limited by other federal and state statutes, for example, the ADA or the Constitution, a First Amendment issue, those types of things. You would always be subject to those types of issues as far as whatever you do or don't do. And as I discussed last time to some degree, I do have some question about whether the statutory authority cited by the county actually would authorize it to do what it has suggested it's doing in its order, and that is ordering the school district to adopt a policy rather than the county enacting a policy directly itself. So what I mean by that is I don't think there's any question that the county would have the legal authority under its statutory framework as the public health officer if it wanted to mandate mask requirements for all citizens in Johnson County. I think they could do that, assuming they had the proper criteria to support the decision and assuming there wouldn't be some sort of challenge made that would be successful in some court process. But the question is whether they would have the authority to require a particular city within the county, for example, to say, say city of Olathe, we're going to require you to issue an ordinance in your city requiring citizens or people in that city boundary to wear a mask. And the city might come back and say, well, wait a minute, you can order the people to wear a mask, but you can't order us to order people to do it. It's kind of the same thing that they've done to you in the way they framed the order. So that's just an issue with what that statutory enforcement might look like. Again, it's hard to navigate and figure out exactly what the outcome of that would be. And I'm going to head to a couple other issues here, but I didn't want this seems like a good place to talk about my conversation with the county counselor. So I reached out to the county counselor concerning the position of the county and specifically some of the comments that were, I think, quoted or have been attributed to the county council as it relates to whether the school district has the authority to exercise home rule or not. And some of this is, I didn't get anything back in writing from the county counselor, but I did want to at least share some of the information I did get. So a couple different things. One, in terms of how how the county went about enacting its order, she indicated that the order was not enacted under the Emergency Management Act, which in her view meant that the statute providing for a civil fine of the $2,500 did not apply. Instead, she indicated that she felt the order was issued under the Public Health Act, and specifically 65-119, which is one of the statutes that's cited in the order. I understand the distinction she's making there, that they're operating under the Public Health Act as opposed to the Emergency Management Act, although reference to both is made within the order. And ultimately, whatever the intent was of the county, a judge or another governmental official who reads the order as sort of a, the third party or arbiter looking at this down the road is going to look at the plain meaning of what the statute or the order says, as opposed to what the intent of the parties behind the order was. So in looking at it, somebody who wanted to pursue that argument could certainly still make the argument that it was adopted, at least in part, under the Emergency Management Act, even though the county is saying, no, that's not what we did. We didn't do it under that act. Now, the county may end up being held to or bound by that if they make that statement in court, but a verbal statement doesn't necessarily get us there. And that doesn't mean that some other entity couldn't rely on that to take place. The secondary issue is that she also indicated the county's intent by not including an enforcement provision and instead of placing that obligation to enforce the order on the boards of education was so that there would be no enforcement by the county. In other words, the county, in her mind, is not intending to seek enforcement of the order. Rather, they have put the order in place as a mandate, place that obligation on the school districts, and they're leaving it to the school districts to figure out how to enforce or not enforce the order. Again, it's a little difficult to understand how that would work. And I remain concerned, and we'll talk about the potential consequences in a little bit. You have all these statutes that are on the books, not orders by the county, not county resolutions, but actual statutes that talk about penalties and potential criminal actions that could be taken or prosecuted for not following a dutifully issued public health order by a county health official. And that includes both orders issued under the Emergency Management Act and under the Public Health Act. And obviously, any representation by the county of what their intent was as it relates to the enforcement mechanism is not binding on any prosecutorial office or other agency of the state or local governments. So again, it reflects consistent with what everybody's being told is, look, nobody's got the intention right now of doing a prosecution based upon this. Nobody's intending to go after anybody for a violation of this. But that's not binding on anybody. And I can think of circumstances that could change pretty quickly where all of a sudden somebody could look at this and say, well, wait a minute here. I wasn't going to use this to try to do any kind of enforcement mechanism. But if a circumstance changes, I could see somebody deciding for expediency's sake that perhaps I'm going to use this as an enforcement tool to get something accomplished. And I'll give you a couple of examples of that here in a second. She also indicated to me that she believed that it was up to each Board of Education to determine whether it believed that it had the authority to opt out or override the county's order. She indicated that in the context of the removal of the opt-out provision from the ordinance, the actual removal of that from the order the county issued was not intended by the county to remove the opt-out as an option, but was rather based upon a belief by the county that the county couldn't make the decision to allow a district to opt out or to conclude one way or the other whether a Board of Education could opt out that rather each Board of Education itself would have to determine under the statute whether it had legal authority to opt out or not. It's confusing to me. But I understand what she was saying. I don't understand exactly how that works. To me, again, a court looking at this down the road, even if they got into a statutory interpretation review and went back and looked at the legislative history, would look and say, well, the opt-in was in there, it was taken out, so that removes some discretion from the statute or from the order. But be that as it may, that's what the county's position is. She agreed that there was no case law or statutory authority addressing whether a county order was superior to a Board of Education resolution or vice versa. So again, we're kind of out there. She also agreed that frankly, the prior version of or Senate Bill 40, which was in place, and particularly Section 1, would have made it clear that the Board of Education had priority in this context over the local health authority. But remember that Section 1 was based upon the governor's executive order being in place, and that order has expired. So that section of that statute is no longer in effect. So it's not there to provide any support one direction or the other in terms of what we're doing. So I say all that just to say this thing isn't easy, and there's no clear guidance, and there's nothing out there that's going to say one way or the other whether you would be successful in seeking to overturn a challenge to the order or not if you guys were to adopt a resolution saying you're going to opt out. I don't believe the county will challenge it if you do it, but I don't know the answer to that. I can't read the tea leaves. I can only tell you what I think as far as that goes, and that's not legal advice, but that's kind of the sense that I get. But that desire as to whether they would seek enforcement or not may change depending on what circumstances change. If we see a continued increase in cases, I could see the county being more aggressive in terms of trying to enforce their order. If we see a decline or there aren't an increase in cases, I could see the county just sort of washing their hands of the thing and letting it go on. And that's I don't mean that in a bad sense. The county has an obligation to protect the health of the citizens of the community. They're doing the best they can to try to do that too. I don't have any doubt in my mind that that's their intent behind what they're trying to do here. We just have a degree of disagreement about who has primacy in terms of what those decisions should be within the context of the school setting. And that's fair. That's why we have governmental units in the state of Kansas. So I do want to indicate that if the board adopts a resolution or attempts to adopt a resolution to say that the order will not apply to a school district, to schools within the district or something to that effect, that whatever action the board takes will not negate the county's order. In other words, you can't issue an order that says we're rescinding the order, or you can't issue a resolution that orders the county to rescind its order. You can't do that. So their order would stay in place. Your order or resolution would stay in place. Both would be in effect unless and until you have a court or a judge decide that one is superseded by the other or otherwise absolved. There are no other referees out there that could decide the matter, and either way you went would require a challenge of some sort, whether that would be somebody seeking to enjoin enforcement of the order, or whether that would be a declaration act. As I indicated last time, anybody who's impacted, who's a person, could certainly file suit or seek to challenge either a resolution made by this board or a resolution made by the county in court. And that would be another possibility, is how the decision could be made as to whether or not one order or the other is in effect, or one order or the other is binding, and what that might look like. Alternatively, it could come in the context of if somebody decides to try to enforce the order, or somebody decides to try to prosecute somebody based upon the order, school official or something like that. And if that were to come into play, then that as part of that prosecution or civil action, a court also could weigh in on whether or not which order has primacy or which order would have greater effect over the other. I can say that if you guys decide to go down the path of trying to challenge this, and again, without talking specifically about, or acknowledging that there's no specific requirement as to what a resolution might look like or not look like, I think that there are some things that the board should do to make sure that its resolution is as defensible as possible. And one of those things is to cite statutory authority that we would have to do that, and we can assist with providing that. I think the other is to provide some citation to some of the concerns we have about our ability to enforce the order, such as the mandatory attendance laws, the fact that we're not allowed to do remote learning by the state this year, due process concerns for student rights if we end up having to discipline students for violation of the policy, things of that nature that would show some of the difficulties that we might have in being able to do what the county has essentially ordered us to do. I think it's also going to be very important that you have some factual bases presented to the board that would provide support for the rationale behind the departure, whether that's information about, educational opportunities for students being enhanced by the fact that they don't have masks on or perhaps don't have masks on all day, other mitigation factors that you think are equally as effective or somebody is saying are equally as effective as the use or wearing of the mask in the sixth grade classes and below. Perhaps some mental health information or medical information that would show that, again, that other measures may be equally as effective in preventing the spread of the illness. I would caution, however, that in looking at that down the road, a court's going to probably give deference to the public health authority over the school district's determination of those medical and mental health factors. They'll give deference to you guys on the educational factors. I don't have any question about that. I just think that as a optic level piece, a judge or somebody else sitting in a neutral capacity is going to say, well, on balance, I'm going to take the word of the health department over the word of a school district on a health issue. That's just my thoughts. Again, I don't have any authority for that because there is no authority. That makes sense to me, particularly since that's what the health department is charged with by statute, as opposed to the school district being charged with specifically the issue related to education. So the last thing, there are actually two things left I wanted to talk about. One are the potential consequences, and two, that you guys had also asked me to look at the insurance. And so let me take the insurance one up first because I think it's a little bit easier to cover and navigate through. I got a copy of two insurance policies the district has. One is your general liability policy. The other is your, I think it's an errors on emissions policy. I think it's called a linebacker policy. And I sent you copies of the policy as well as the email from the carrier. The carrier obviously is of the opinion that the board should follow the county's order, primarily, I think, because the county's order, by virtue of how it's worded, gives the school district immunity from claims based on a specific statute, and that's in that KSA 6055. I think it's 04, but it might be 01. I'm not sure which one it is. So under that, the auspices of that, obviously, if you're immune under that statute by following the order, the carrier never has to pay anything out on any kind of policy. So that's a pretty easy thing for the carrier to say. But in looking through the policies themselves, a couple of things come into mind. One is both policies are limited by the Kansas Tort Claims Act. That's standard language. Every insurance policy for every school district or county is going to say that in it. And that just prevents anybody from recovering more than what they could recover under the Tort Claims Act. Why that's important is, and I talked about the Tort Claims Act later on, is that the insurance would sort of be covering you for what would be covered under the Tort Claims Act in these contexts, unless somebody can come up with like a civil rights claim or something like that. The other issue in the orders is, or the general liability policy is the policy that would primarily cover you if somebody got sick or got injured or ill at school. And there is a specific exemption or exclusion under that policy for contagious diseases or illnesses, which they would argue includes COVID. So if somebody sues the school district because they are claiming they got COVID, your insurance carrier may decide to cover you, at least for defense, but they're definitely going to point to that exclusion and say, if you get sued, we don't have to cover you. And if you get hit for damages, we're not paying. I mean, that's basically what they're saying. Now, they're not giving you a formal opinion because they're going to wait till they actually get a real claim and decide that based on the real claim. Because if they went a different direction, they'd end up with a potential bad faith issue. So they're never going to give an opinion out of the gate that says, we're absolutely not going to cover you under situation XYZ. They're going to wait till they have all the facts from that situation before making that decision. The other issue relates to the errors and omissions policy. And so that's the policy that would likely cover the district in the event that for actions taken by the Board of Education that end up violating some statute or law or violating somebody's rights. Same thing for actions taken by other school officials or employees that might violate somebody's rights or create some action. So think about, if you guys have a search and seizure statute or policy, some building principal searches a student and the student sues the school district because they claim that their rights to privacy were violated, they would provide a defense under that errors and omissions policy because the actions were based upon board action and also based upon the school officials' discretion and duties in the scope and course of their employment. What that policy includes within it is a section that says, well, that's all well and good, but we're not going to cover you for intentional violations of the law. And so the language is vague. There are some specific statutes that are cited that are clearly covered. There are some others that then it says other statutes that might be of similar nature. One of the statutes cited is OSHA, which is a safety statute. I'm sure some of you guys are familiar with that. So the question might be, is something related to a contagious disease? Is OSHA sufficiently broad enough to bring that within the purview of the exclusion under the policy? Again, they're not saying they wouldn't cover it, but they're definitely pointing to potential exclusions under the policy that suggest that it would not be covered. So again, that's not a definitive one way or the other, but understand that your insurance may or may not cover a situation depending on what specifically is alleged or what specifically happens. And they also would not cover they would only cover damages. They would not cover any fines. They would not cover any defenses that relates to any kind of administrative proceeding, a licensure proceeding, a criminal action. That's not something that the insurance company would cover. So that takes us to the consequences. And, it's difficult to figure out in this context because we don't know what the circumstances would be under which somebody might or might not pursue a consequence. And again, my job here is not to, I can tell you what I think might or might not happen, but my job is to tell you from looking at the law and the statutes, what the possibilities might be. Because you need to make decisions sort of eyes wide open of what the potential consequences might be, as opposed to, well, I don't really think that's going to happen. So, and I don't want, 6 months from now, something happens and you say, well, Greg, you never told me about that possibility, right? So I'm giving you sort of what I've gone through and looked at and said, well, could this fit the fact pattern here and cause a concern or an issue? So the first issue, and I kind of ran through consequences that might be visited upon the school district itself, as opposed to individual employees or of school officials. And those consequences include the school district could face an attempt for an injunction brought by either somebody outside the county or the county itself, although again, the county has indicated they're not inclined to engage in any kind of enforcement action. They certainly have the authority to do so under their statutes. They could seek the closure of a school or shutting down of a school activity if there are violations of the order, similar to a health code violation. There is certainly, whether they decide to do it or not is a totally different question, but would they have the authority to do so? Yes, they would. Whether they would be successful in that endeavor would be something up to a judge. But they certainly could come in and say, hey, you know, go to one of your elementary schools and say, nobody's wearing a mask in here, we're closing it down. That is a possibility. Again, they've indicated they wouldn't do that, but I don't know what would or wouldn't happen in that context. Those are some of the things that might be done. And then as it relates to school officials, which could include board members, employees, or other agents. So you guys have some people in your buildings that are contracted, they're not employees, that would fall under those folks as well. There could be various sorts of civil, criminal, or administrative or licensure actions that could result as an issue or a potential problem. And I say all of those folks are involved because at least the initial phrase in the first part of the order places the order on schools. And by statute, your schools are subject to the orders and direction of the Board of Education, but then your superintendent and the different administrators are placed with the charge and authority and control over the school in the times in between the school board meetings, pursuant to whatever board actions taken. And school teachers and other school employees are given charge and control of custody over school students and their classrooms and school facilities and activities. So all of those individuals would be subject to the order because the order is directed at the schools, the public schools within the district. So some of the issues I see, and I cited some of these last time, obviously, the county has, the order itself states that it's issued pursuant to 65-119, 65-202, and 60-5502. It also includes the catchphrase, other applicable laws and regulations, which is what, based upon that third whereas clause that talks about the order for the emergency or the emergency local order, arguably places KSA 48932 in play. And again, the county councilors indicated that they intentionally did not take action under that statute. And so their position would be that provision of enforcement under that allows for the civil penalty of up to $2,500 would not be in play. But leaving that one aside, you have various statutes, including KSA 19101D, which allows for a violation of and basically the statute 1901 in general, which is the effectuating statute for KSA 65-119, the statute they say they've acted under, says the county has the general authority to enforce any resolution or code violation by enjoining violations, prescribing penalties for violation by fine, by confinement in the county jail, or both fine and confinement. And it says the statutory authority is limited because it says, unless otherwise provided by the resolution that defines and makes it punishable, the violation of such a resolution, the penalty imposed shall be in accordance with the penalties established by law for conviction of a Class C misdemeanor. And here they intentionally did not include a specific enforcement mechanism or a specific penalty. And so as a result, the default provision of the statute would make it potentially, if some prosecutor decided to do a prosecution, a charge could be brought for a Class C misdemeanor, and you could also seek a fine. I can't remember the fine. I think it's limited to like $100 or something like that. So it's not like a huge fine. Similarly, and I talked about 48-939, that's the one with the $2,500 penalty. There's no criminal provision associated with that particular statute, but all these statutes say that in addition to any other fine, penalty, or action that might be prosecuted under the law, so they're not limited to their specific statute. 127 would deal with 119 as well. That's the one that says a fine between $25 and $100 per occurrence or offense. Also, I believe contains a provision for a misdemeanor in there as well. And then you also have some other statutes that could come into play that all will go into that concern or issue. I also pointed out and need to point out that you got some other potential statutes that could have greater exposure. For example, an argument could be made under the right set of facts. Again, I can't see the county or the prosecutor doing this again, without the right set of facts. But one can make an argument that if you have a public health order that requires the use of masks for kids in public schools under the age or 6th grade and below, or in buildings where somebody's 6th grade and below, and you have the school district saying we're not going to do that, and you have a school official, that building principal, teacher, whatever, that allows that to happen, and so you're not following the public health order, and somebody gets COVID and gets severely sick, that can change the dynamics pretty quickly. I mean, if all of a sudden you have one of your elementary schools and you're not enforcing the county's health order, you're allowing kids to be in there without a mask, you're allowing adults to be in there without a mask, and some kid or group of kids contract COVID, and say you have a couple kids die. We say it's that severe. I mean, that is a possibility. And if that possibility occurs, I can see very easily.
Hey, Greg, just one reminder, remember, this is a meeting in the open. If it gets disrupted, I'll either have you removed or we'll just clear the room out and we'll finish watching YouTube. We're going to be respectful and we're going to listen with an open mind. Just a reminder.
Okay, so the issue there obviously would be, and that may sound like an extreme situation, but if you picture that situation, you can see how somebody's decision to say, well, I'm not going to prosecute, which isn't binding on anybody. I mean, you could change your mind tomorrow about that if you present a different factual situation. You could charge perhaps with endangerment of a child. You could charge with neglect. You could potentially charge with aggravated if the child gets severely sick or injured or something like that. And if you have some situation like that, that would end up being a felony charge if it were brought. And again, I'm not saying it would be, but that is a possibility that could exist. Any teacher or administrator or other licensed professional that is charged with any of those types of violations would potentially run the risk of losing their license. It could face an administrative procedure for that. Under the professional licensure statute, you do have a code of conduct that's adopted by the state. Under that code of conduct, that includes things like ensuring the safety of a minor child, and those types of provisions in that code of conduct could be construed by an administrative official as violating that code of conduct by not following the public health orders issued by the county. So again, that's something that is a possibility. Professionals and teachers and all employees have a mandatory reporting obligation. And again, that includes neglect based on health or safety. Somebody could complain about health and safety violation and report a neglect based upon a failure to follow the county order. If that were to occur, DCF would have the jurisdiction to investigate. I don't know whether they would choose to do so or not, but they would have the authority to do so in an administrative proceeding. And if they did that, they have the authority to issue substantiated or unsubstantiated findings in that regard, which could be ultimately challenged in court. But in the meantime, those findings could end up being in effect. And again, these are all extreme situations, but these are possibilities that could exist. And the reason I bring these up is because if you decide to do this and make some departure from the county's order, you potentially place your school officials in a situation where they're having to decide whether to follow the order of the school board or to follow the orders of the county. And they could have consequences for either situation. They could make an argument, I think, that by following the county public health order, they're protected or insulated from retaliation. So perhaps the district couldn't take action to terminate or otherwise discipline the employee for not following the county's order. Vice versa, if they chose to follow the district's order, they face the possibility, however remote it might be, that the county or some other public body or agency might decide to go after them for violating the public health order. So that is something that this district cannot control. That is something that other people would make the decision on, not this district. And so that's the difficulty you have in trying to sort of walk through that line of what that looks like and whether and to what degree you could enforce any order against any particular official within the district and what that might look like. Lastly, as it relates to claims by any student or any other individual who might contract COVID from the school or claim to contract COVID from the school setting, and whether departing from the public health order would have any kind of impact upon that claim. I think any claim that somebody contracted COVID from any particular situation or from any particular contact is going to be difficult. However, you can see some patterns, and you're seeing this in the context of OSHA reporting and in the context of some workers' compensation claims, where there's contact tracing involved. The very act of the contact tracing sort of establishes where the person may have contacted and contracted the illness. And that contact tracing is part of what you have as the ongoing process. And so, it certainly is within the realm of possibility that somebody could establish that they contracted it from a specific location, such as a school setting or whatever else the case might be. I think it'd be hard to prove. It's a illness that is or a virus that's transmitted. You can pick it up about anywhere as near as I can tell. And so if you're not limited in your contacts, then you've got some degree of defense there. That burden of proof would be in place against the school district, just like it would any other location or entity. In addition, because of the Kansas Tort Claims Act, there would be some immunity against those types of claims that could be raised. I don't know whether they would be successful in that context or not. Specifically, there's exceptions for adopting or failing to adopt a policy, for failing to enforce or not enforce a policy. There's an exception for that. But those policies also at least have a provision that talks about that exemption not being available in the context of a public health order or public health directive. So there would be some degree of possibility that exemption would not be available in that context. So, it's hard to know without knowing a specific factual case. I'm not aware of any claims that have been brought in Kansas by anybody claiming to get or have contracted COVID and suing an employer or a place where they ate dinner or visited or anything like that. But it's certainly not within not within the realm of possibilities. If an employee got it, I think you would argue that it would be under the Kansas Workers' Compensation Act, and whether it would be covered or not would be something that an administrative law judge would decide. If that all came into play, and if you had some claim of negligence being brought, the argument over whether you followed or didn't follow a masking order by the public health body would be fair game for discussion in that court proceeding. Whether it would have any impact at the end of the day, I can't say at this time. So that's kind of the lay of the land as far as everything that I've tried to take a look at. I know that there are some private schools that are looking at things like indemnification agreements or releases signed by parents. I don't have the ability to weigh in on what considerations they've given as to whether to use those or not. I don't represent any of those entities. I've not been involved in the analysis of that. I've looked at them, or at least looked at a couple of them. I don't think they would protect or insulate the school district if you decided to use those. I think they are simply documents that if you wanted to collect to show that you provided some degree of notice to parents, I suppose you could do that, but I don't think they would prevent anybody from bringing a claim if they chose to do so later. So I don't see the real benefit or use of those in the public school setting. And I certainly don't think that if you're looking to have some sort of medical support for a child, like you would under the ADA, for not being able to wear the mask, I think having a licensed professional would be more effective as a defense to that issue than having a parent or a lay person sign off on something like that. But again, that's something, if you guys decide you want to head down that path, we can take a look at in a little more depth and see if there's something there that could be looked at or worked on. So that's the summary of my update. I'm obviously happy to answer any questions the board may have, and help effectuate whatever you guys decide you want to do, whether that's continue the status quo where you're at with the current plan in place, subject to the order entered by the county, whether you decide you want to effectuate some sort of resolution, trying to put that in the best format you can to provide one that's defensible and supported, so that you can accomplish what you want to do.
Questions from the board for Mr. Goheen?
Just to make sure that we're clear. So it was Peg Trent, the chief legal counsel for Johnson County, that you spoke to today? Is
Yes.
that what you said?
Yeah.
And to kind of break all that down, I don't mean to simplify it completely, but she said that there's no plans to enact enforcement. What about civil fines?
I don't think they plan to pursue civil fines either. At least that's their current intent, as reflected in my conversation with her.
Okay, so we have Sheriff Hayden saying it's not going to be enforced for criminally, and then the county legal team saying not civilly.
Yeah, and understand that any statements that the county or the sheriff or the district attorney make are not binding on them. They can change that decision,
Sure.
In a 5-minute course of time.
Right. Yeah,
Yep.
District Attorney Steve Howe did state yesterday, he was gracious enough to take my call on a Sunday afternoon, that they have no intention as well to enforce it or look into this at all. He wants to stay completely out of it. So that those things are important to me.
But again,
I hear you.
it's not binding. I mean,
I hear you.
it's not something that, you can't ask a law enforcement officer or a prosecutor or even a county attorney a question in the abstract and say, are you going to enforce this or not? And then bind them by that decision. They still have the authority to change their mind, whether it's just their changing of their mind, whether it's a changed circumstance, or maybe the hypothetical that they were considering is not the same as when they actually look at the specific situation.
Sure, I understand that, but I think as we're looking at the order and looking at what it states, as far as it doesn't say to schools that are to enact the order or enforce the order, it does specifically state the Board of Education. So I want to be sure.
It does that in section 2, but in section 1, it says schools.
I just want to be sure that we are, a week ago tonight, we heard that the teachers could go to jail or lose their houses, and none of us want to put anybody in those kinds of positions whatsoever. For civil fines, but if the county, if she is stating as their chief, I understand she's just saying it, she could change her mind, but that does definitely weigh into the decision-making process. So thank you for getting that information.
Yeah, and again, just to be clear on that point as well, you're not making a decision as to the enforceability of that as to, the board only. Individuals would have to weigh in on that, reliance of that as well. So,
Yeah, I'll say that enforceability does not affect my decision at all. People can change, they can change their minds. Enforceability is not, it doesn't affect my decision on what we do this evening or not do this evening. From my perspective, there's a couple of things that I guess I want to say before I get into the meat of it. My statements are not, or I don't want them to be construed as for masks or against masks. I think that this is a legal issue only. This is not about data. This is not about students. This is about the legal authority we have or the county has at this point. I think we've made kind of, I mean, we didn't take action, but we kind of made a decision on whether we would have masks in the school, that it's optional, but I want our teachers to know that I support them, that I support our students. I support our parents and constituents and staff, administrators. But I also want to say that I believe that this order has, that the county actually violated or superseded their authority based on 72-1138, section E, subsection 2, when they said that we shall have masks. They created a responsibility for the school district that we didn't have. They also said that we had to enforce that mask mandate, which is relieving them of their enforcement and putting it on us. So in my opinion, that the order violates that subsection. I would prefer that we send in a complaint or a letter to the county based on that, ask them to amend or rescind the order, and see if they'll do that. Now, whether they do or not, that's up to them, but at least we're asking instead of going straight for a resolution. I think it's working cooperatively with the county. I think it's important that we do that, at least ask them based on this. Beyond that, I would like to see a resolution if the board wants to go that way. I don't know yet if I would be in favor or against a resolution, but I will say again that according to Kansas statute, I think that they've exceeded their authority.
So I do agree with you in that, Jason, for sure. I think it is important. And I do want to stop here and say thank you to Mr. Goheen for your insight. And I agree that from what you said at the beginning, that it is your job to present the information, it's our job to then make the decision.
Right.
And I think that's a really important and appreciated distinction. I think it's important that we educate ourselves. And I think we've spent a lot of time looking, reading, researching, trying to find out what exactly it is. And I mean, I feel like we're kind of living in a big civics lesson at the moment. I mean, a law is created by the legislators. Thank you to Adam Thomas. He's here. But, you know, they write them, then it passes the House and Senate and goes to the governor. So I guess if nothing else, as a Board of Education, we are educating our public right now too. So I also agree that this is about legality, constitutional rights, transparency, and leadership. That's what this is about right now. This is no longer about the efficacy of masks or what the data is, even though I do appreciate having very transparent data. Thank you, Commissioner O'Hara, for bringing us the data. I do appreciate that. But the Board of Education as a whole, not her individually, as a whole took all of that out with bandanas and towels and things. So I was really interested today because I know that everyone sitting up here is very much a person of their word. And so I emailed Katie today because I was curious, like, exactly what have we agreed to sit up here? And what did our oath say? And it said, I do solemnly swear that I faithfully discharge my duties of the office as a member of the Board of Education, Spring Hill School District number 230, in accordance with the Constitution of the US, the Constitution of the State of Kansas, and the laws of Kansas to the best of my ability. That doesn't say to the county because the state supersedes the county. But in that, Adam Thomas keeps directing us back to Article 6 in the Constitution about local public schools. It says local public schools under the general supervision of the State Board of Education shall be maintained, developed, and operated by locally elected boards, which is what Mr. Goheen referred to as well. And if we don't have the authority, then why do we have a locally elected board? What is our purpose here if we don't hold the authority to govern the school district? And quite frankly, everyone keeps passing the buck. I agree with you, Jason, that we should engage the county and bring the statute up that you brought up. But I also am not willing to leave here without taking the lead and taking a stand for our parents, for the overreach in government, instead of just it feels like everyone is passing the buck here because as Mr. Goheen said repeatedly, there's no definitives here in any of it. There's just not. So what happens there? We're just talking in circles. The county's talking, the doctors are unwilling to sign because they're being threatened. So then it's like all these people passing the buck. Who's going to stop? When is it? Who's going to stop and say, well, I'm done and let's stop this train because it's tearing apart our community. It's tearing apart our families. But I do think that it's valuable to look into what some of the private school, obviously they've been legally advised by their own legal teams, what they have done. And, I sent that today, I think, and I know probably everybody didn't have a chance to send it to Katie, send out to read through that. I do think it's very interesting that there are private schools that, and they're listed in the order, but that they gave the opportunity. The thing that I want to say most clearly that they said in there is nobody cares about these kids more than the parents, than that individual parent. No one does. I don't, and you don't. None of us care about those people's kids more than they do. And they know their health limitations. They know. So they did put the parents on the opt-out, the mask opt-out form, just like we chose as a district to add chiropractors. Other districts don't have chiropractors on there. We get to, so what the order says is we get to make the decision in that. So we could add the parents as the opportunity to sign the mask exemption. That feels a little bit like a compromise to me. Then we're not saying no to the county no matter what, but we're also giving the parents the freedom to make health decisions for their own children. I just feel like bottom line here is I want to listen to the parents. I want to listen to the people, and I don't want them to feel like we think we are better at parenting their kids than they are, because we're not. They're the parents. So as far as liability, I appreciate that you said there have been no COVID claims in Kansas, and it would be really hard to prove. I mean, when we look at, Dr. Burke said on the July 26th meeting, that part of the reason that we were going to do mask optional is after what we've all observed in the community, right? I mean, these kids are instantly together as soon as school is out. They're all over the place. They're indoors, outdoors, everywhere. How could anyone ever prove that they got COVID at school? It just doesn't make any sense. And quite honestly, could somebody sue us because they got COVID? Well, what if somebody were to sue us because just tonight, one of the teachers at back to school night was telling me the masks end up so wet by the end of the day by the little people because they chew on them. I mean, maybe they could sue us because we forced it upon them and now they have a bacterial infection because we've created a petri dish that's on their face. I don't know. They could decide to sue us for whatever they wanted it to be. So, and yes, they can close the schools. They've always had the ability to close the school, right? If our flu numbers got too high, if hand, foot, and mouth numbers got too high, the health department has come in and closed that classroom or that school. So with that, I am absolutely in support of a resolution of any way we can find to give the authority back to the parents and not from us or the county. And I did, just in case you're interested, I made the copy, so you might as well take them. The Archdiocese of Kansas City, like exactly their wording, what they're doing, and then also HCA and their wording and exemptions on what they're doing. So we can enter those into the record too.
I guess before I came here tonight, reading over the order again. And to me, maybe you could clarify this a little bit, but it seems like to me that the wording is pretty vague on the masking and the medical exemption. It says mental health. I actually think that personally, I think that would maybe be a better route to go, because it does give, I mean, we've been getting lots of emails on both sides, and the people that really want us to follow the health order, what I've heard from many of them is that the people that don't want us to follow the health order is a pretty small group. So if it's a pretty small group, it shouldn't matter if they sign exemptions for their kids. It wouldn't be that many kids
not wearing masks in school, if that's true. So I think it might be, like you said, kind of a compromise where we wouldn't be going against a health order. So for our insurance purposes, we wouldn't be asking staff and whoever else to not follow the health order, but it would give parents some more control. So that's all I got right now.
Sharon, I was thinking about something along that line as well. If we, like I talked about last time, if we choose to not approve the order and not disapprove the order, just live with it, it's up to us to enforce it. And I think everybody needs to remember, this is mask optional. We're not saying no masks. I think a lot of people are thinking it's none, and that's not the case. So if we chose to not go either way with it, it's up to us to enforce it. If we had a teacher that didn't want to do it in her classroom or his classroom, that's an option, in my opinion. That would be up to us to enforce. And if the county's not going to enforce it, why would we have to enforce it?
I wrote down that quote too. I think Greg said other people. The county is saying other people, they can't force us to enforce other people, right? So
Say that again.
essentially, correct me if I'm wrong, he was saying the county can enforce the people, but we can't enforce the county's order on the people. See what I mean? So it's like a domino effect.
But they do have occupancy rule, right?
Yeah.
So if they came in
Yeah, it's
to a classroom
it,
and there was an issue.
yeah.
they shut us. They could
This
close us.
this kind of goes to the whole, I think Swinbolt was talking about this, is that and maybe this goes back to the civics lesson. And I've been equating this to a law school examination question where you kind of going back and trying to figure out, what commas mean in sentences and what's out there and what's not out there. Yeah, I mean, the big question in terms of how this is written, which is totally separate and apart from any issue on the authority to do a mask mandate or not. I think the county clearly has authority to do that in general, just like.
So I'm sorry, I didn't.
I said, I think the county would have the authority in general to issue a mask mandate if they wanted to do that. What's peculiar from my sense about this particular order is the way it is written doesn't directly issue that type of order. It orders the school district to do so. And just like the school district can't order the county to undo its order or can't order the county to do a different order, I'm not sure the county can do the same to us. So that's always been since I've read this, that's been my sort of procedural question. But again, that's just my look at it. KSB read it and they concluded that the county could do so. So, you're going to have different lawyers with different opinions. And ultimately, none of our opinions matter at the end of the day, other than if we happen to have a black robe on and are sitting at a bench in a courtroom. So, I think that is part of the civics issue here, and especially I wasn't sure if you were asking me a specific question or not. I think you were, and I think it related to. Could the district do something short of saying, hey, we're not going to follow this, and do some kind of resolution to set requirements for what the masking piece might be, or what requirements there might be for other aspects of this? Is that what you're asking?
Yeah, my question was more that would you agree that it's kind of loosey-goosey in how they have it? I wouldn't want, that's real technical terms there.
I don't think I should use that term.
But I mean, it's pretty vague in how they're saying to even follow an exemption for a mask.
It's pretty open-ended, and I think on purpose from the county. I mean, I think that in fairness to the county, I think they were trying to take into account things like the mental illness aspect of having masks on that might be having on children, because I think we've all heard that. I think that, and there has to be a weighing of that against the efficacy of the use of the mask and preventing the illness as well. And I think that in some ways, the way this was written is offering up to let the schools balance those things out in terms of, what does that look like? And I think even you've got some piece of that in the education. I think there's a section that talks about children who need to remove masks to be able to learn effectively or something. I mean, it doesn't say it that way, but I think that you could arguably, if you want to try to create some sort of clarification of the order or limitation of the order based upon establishing the criteria for what those things look like, I think you probably could do that if that's what you were.
Would that have to be done at the board level? I mean, because we didn't draft or craft.
You could direct administration to take a look at that. And I mean, ultimately the board could approve it if you wanted to approve it, but that is something that you guys could look at as to what does the requirement for, I mean, there's a definition in here for mask or face requirements. I don't want to use your word loosey goosey, but it's pretty broad. There's also, like I said, a couple of the exceptions on the exemptions. Let me try and see, make sure I got the right, I don't want to misstate what the order says.
So I do appreciate that you also mentioned mental health in that.
Sure. That's in the first, that's in
Yeah.
2A.
Yeah. I think that that's important. And so did you get out? There were 3 handouts, Dr. Burke. Did I skip one for you? Sorry.
So
You got
the
it?
piece
Okay.
that I'm afraid might be missing here is the parents that want the mandate. Right? I don't hear a lot of conversation about that. I hear it very one-sided, and I think it's really important that we take that into consideration and that is brought to light and have a conversation around those that want. People that want the mask mandate have very reasonable, compelling, justifiable reasons that they want that mandate. One of our obligations as a board within the district, and the state constitution tells us why we're here, by the way, Ellie, is what our purpose is. But the reason we're here is to create an environment that's conducive to education and learning. This thing's turned into a power struggle between the county and us. I don't see how that helps us support creating an environment that's conducive to learning, to teaching, to administering our mission. Part of that environment, I don't want to create something that causes teachers to always be looking over their shoulder, that creates an anxiety that impacts their ability to be effective at teaching. I don't think it's a good move. Going along with that is that students need to be in an environment that they aren't around adults that have anxiety about whether I saw 16 reasons as Greg went through this. I wrote down 16 different potential issues that we create for ourselves if we go against this mask mandate. That's number one. Number two is I know everyone's getting these emails of parents because I see people copied on them. I see the other board members copied on them. And I think that's a significant part of this conversation is the parents that support this mask mandate, because they're from their perspective, from what they're talking about is this is a safety issue. This is not a power issue between the county and a school board. This is a safety issue for their children. It's about that environment that needs to be created so that their students, their children feel safe where they are. It's about teachers that feel safe and comfortable about teaching and performing their job. It's about administrators that don't feel threatened and always looking over their shoulders to where's the hammer going to come from when you have 16 different directions that this thing could hit you from. There's a lot of stress. And so what's the focus? Is the focus on anxieties and wondering if the hammer's going to fall? I mean, I know we have verbal conversations from people that really aren't worth the breath that they were spoken, because they can change their mind at any point in time. So I think we have to round out this conversation with both view from both sides. And to date, this has been just very one-sided conversation. And so I think we need to broaden our perspective, broaden how we view this, so that we can take into account the entire district, not just one side's perspective, or one view's perspective.
I agree with that. I agree with what you said. I think that we don't want to create anxiety in the teachers. We don't want an environment that's anxiety ridden in the classroom. I think this whole thing has lent itself to either way with that. Anxiety for the teachers to have to be the mask police, or to have the hammer fall down. I mean, there's been many teachers that have reached out and said, I can't teach effectively and try to keep 22 first graders in a mask. I'm constantly worried about them. But I agree with you. I think that parents that are emailing us about the mask mandate have very valid concerns, and I can't discount their concerns either, just like I can't discount the other side. We have to listen to both of them. And if I think that the county, the health department, the BOCC, when they wrote some of those, in Sharon's word, loosey-goosey things in there, the credibility for some of it was just thrown out the window. I mean, to say you can tie a towel or hold a t-shirt up around a child's head, then I'm wondering, do they really care about safety? I can tell you that healthcare workers are extremely burnt out and tired. I mean, exhausted after these 18 months. And there were healthcare workers in tears when the order came out, because they felt like it was a gut punch to them, that the county put something so frivolous out, that they've been working so hard to combat COVID. So that comes into my thought process too. It absolutely, everyone's opinions matter. All of it matters. And it should all be validated, but they should have the choice. They can still protect their kids. They have options. We all have options.
They're specific about following the mandate.
So I wanted to offer a possible compromise and kind of take it into, I was kind of thinking both that I know which side I'd be on, but I can certainly think and understand people being on the other side. That my thought was let's follow the lead of the private schools and allow parents to sign an exempt form, but let's try to make that for classroom only. I mean, you could have your mask off the whole day in the classroom. Anytime you're in common areas or in the hallway, you wear your mask, and then people that are scared of it, they feel like they're protected. And so, and I don't know how that works out logistically, whether we've got two people that want to not wear a mask and 98% do. I mean, that might be a problem, but if we had, or the other way, but if it was split pretty 50-50, then that would be a way to make people still be able to sit in class all day long without a mask on, but yet people that the students that are scared of everybody else, they could be around everybody with a mask on. So that's kind of what I was thinking. Is there a way to find a compromise that we could kind of touch both? And it's not perfect for either, but it's a way to come up with something.
Let's think about unintended consequences of something like that. I mean, that's what our job and our role is. If we allowed parents to sign this, what would you call it, an opt-out form? Or
It's a medical exemption. I mean, that's essentially what it is.
Where does that end? We have other forms that we require other professionals to sign. Where do you draw that line? Is it just specific to this form? Is it specific to, does it go to all forms? I mean, we don't want to create a nightmare for our administration and how they have to manage and administer something like that.
I would request that if you're going to do this, you need to be very specific and say face mask only pertaining to this order.
Absolutely.
Because I mean, we have protocols for concussions, we have all kinds of other different things. So if you
Specific to this issue.
it needs to be very specific and refer to this specific order. Otherwise, you're right, you're opening it up to, because then it'll be parents' rights for all medical decisions, and then we're gonna have a lot of issues.
I agree. This was specific to this issue. And I don't think we have any idea what the numbers are either. Thoughts of either.
No.
Say no, absolutely no idea.
No.
We have no idea what the percentage of people that
Mask.
would want to wear a mask versus not.
I don't think we have an accurate number.
I would also request that if you're gonna do it, just do it. Trying to police this to say that you can only have it in the class, but then you gotta wear it in the hall and all that. If you're gonna allow the parents to do that, then you should just open it up.
So it's not a motion, it's a resolution.
I don't think that handing it back to the administration would even require any action on it.
No, you're gonna need to take action on
Yeah,
that.
they're gonna need action for that.
Because we've got it on the website. It's also talks about medical forms. So we're following what we previously done. If you're going to do this, you need to take action.
So we need
It
to
won't be-
motion for action then? I'm sorry, I'm just wanting to
It
understand.
would be
Yeah,
a motion for
motion
action.
or-
Yeah, we'd have to add the action item and then vote on that
Okay.
action item. The resolution wouldn't apply at this point. I
I
mean,
gotcha.
You're only doing a resolution if you're completely ignoring
Okay.
the state mandate. If you're just doing mask, it's just
I'd like
Yeah,
to, I'd like to,
I think. I'm trying to think through the best way to do this.
This is not
I mean,
something.
I think you could by motion, if you wanted to say what you're going to require as the proof or whatever for a condition or that would exempt the person from the mask under the provisions of the order. What I'm trying to decide in my mind is that if you do it that way, it would not necessarily fall under the section of the statute that has the, what everybody's calling the limited home rule. If you're going to do that, it still would have to be a resolution. So you'd just be tying that to your other statutory authority and not that specific provision. I only bring that up because if I got to defend it, it's easier to defend.
are you talking
resolution.
about adding parents to the exemptions? Who can give an exemption or?
So I
something
don't know.
else?
I don't know what you're contemplating doing. I mean, I've heard a variety of different things. I'm just talking about the vehicle under which you do it. So you could certainly do something by motion, but if you do something by motion, it will not be an action under that specific statutory provision that has the broadest grant of authority to the school district. So if I'm having to defend the action at some point, I won't be able to argue that you did it under that statutory provision unless you do a resolution. Does that make sense? I know it sounds hyper technical. I'm just,
Well, it's very protective as well. I mean, if we
Right.
say which statute we're using to create our exemption, then in a resolution, then we're more protected on what he can defend on.
I understand. I'm gonna try to cut it. So right now on our website, we have a face mask medical exemption request form. The board, right now, what we've done in the past is it needs to be a medical professional, school psychologist. We would actually allow a licensed therapist, professional licensed therapist as well. What I'm hearing the board saying is they would like to add parent to that. And so it would only refer to this face mask medical exemption request form. And then that absolves the issue that I'm worried about of just opening it up, the whole thing medically.
I see what you're
Dr. Burke, do you know, and I was going to ask you this question as you said that, the medical form or what the district, I don't know this off the top of my head, but do you guys have a policy on what you accept or don't accept by board policy, or is it strictly by administration?
I would say we don't have a specific meta or policy. Brad's probably quicker and faster on that than I am. But in the past, we basically have said we will only accept doctor's notes.
Right.
Now that there's some exceptions such as a PA what is it?
MP.
Yeah, NP. And
Yeah.
then in this specific incident, we get psychologists. So on past practice, that's why I'm saying I think that they would have to vote on this to add parent to this specific form. So instead of doing a full resolution to go against the mandate, all the board is doing is saying we're adding parents to this specific form.
And what I'm saying is that I think you could do that by motion, but if you do it by motion as opposed to resolution, then you're, to the extent somebody is trying to challenge that at some point, I could not use that one statutory provision to say that was the authority you're acting under.
So could we do both?
Sure.
I mean, is that overkill or is that,
Well,
I mean, you could approve the form and then go back and do a resolution or
yeah,
at the same time?
yeah, I think so. We don't have a resolution written up, but I mean, you could,
But the resolution, they're not wanting to challenge the math,
I got it.
okay,
but
I'm just
what-
making sure.
But what I'm saying is if you read that statute, it says if you're going to take action under that statutory provision, it has to be by resolution. And so all I'm saying is you guys can do it by motion. But if I have to defend it, then I can't rely on that broadest grant of power to the school districts as a basis to defend the motion. I could only use the other statutes.
So I'm gonna ask you a what if.
Right.
So what if they go ahead and add the parent to the form now and they vote on that
By motion,
tonight
right?
by motion? And then we have the resolution by Monday. Could we
Right.
put that in effect?
Right. And then you just have a short window when we wouldn't be able to use that form of the statute to protect the action of the board.
So we could get the form out tomorrow, but the action, and it would be binding, right?
The motion would be binding, subject to somebody challenging it. But,
And then we would actually have the resolution. We could get a week and bring it back next Monday.
right.
Okay, so we can motion for it now, then do the resolution on Monday, correct? Would it be possible, Dr. Burke, I mean, you said it would be out by tomorrow. Can that be electronic also, or does it have to be? It can be, they can do it online.
If that's the will of the board, we'll copy something from here. Again,
I'm just thinking that the increased work on the staff to also have to process forms and try to keep track of who's who, and maybe it's easier in an electronic form.
I'd rather have I mean, if we're gonna do this, I'd rather have an actual signature from the parent than just an office.
I started to say it's gonna be a signature because I'm gonna be very honest, nobody's ever gonna sue you until they sue you.
Right.
So
Okay.
the form needs to be written and signed.
Gotcha. But there's ways to sign online too, right? DocuSign and things.
There,
I think if this is important enough, people can take the time to print it
Okay.
and get it to us.
Yeah, I agree.
Okay, that's fine. So I guess with that, Mr. President, I would like to motion to add an action item to the agenda.
Second,
It's moved and seconded to add an action item to the agenda. Katie, please collect the vote.
Mr. Wimble,
Yes.
Mr. Updike,
Yes.
Mrs. Mitchell,
yes.
Mr. Anderson.
Yes.
Mrs. Sealing
Yes.
and Mr. Hoffman.
Yes.
Approved.
With that, Mr. President, I would like to motion to add parents to the mask exemption form as a way to opt out of masks
Can you add pertaining to this mandate?
pertaining to this mandate.
Could the clerk read how the motion would read, please?
Is what we had was add parent to the mask exemption form to opt out pertaining to this form only.
I got everything we need in it.
I think you need the title, the exact title of the form.
What's the
It-
exact title?
She said it.
On the form itself, it says face mask medical exemption request form.
Okay, to add that to your motion.
Yes.
Can we put or amend this to say that the parent is the authority, because we say the medical provider is the authority on exempting, or chiropractor.
You know, there is what I was planning to do, Mr. Winbolt, and I'm sorry, I'm trying to pull it up. There is a list of people there,
Mhm.
such as a MD, OD, DC. I was going to put parent in there,
Parent or legal guardian.
parent or legal guardian.
And Mr. Goheen, could we also add to the same motion to direct staff to generate the resolution with that kind of tie?
You could have that. to the
Yeah,
motion.
that's,
You're gonna have to say it all over again.
say the whole
Tie it
thing.
together then.
Okay. So, Mr. President, I motion to add parents to the face mask medical,
guardian.
parent or guardian to the face mask medical exemption form directly related to this order.
Perfect.
And,
And resolution.
oh, and direct staff to create the resolution. Create resolution.
Got it.
Mr. Goheen, everything sound good, that no changes that you would recommend?
I think so. I might need it read to me again. There were a lot of changes to it.
Okay,
No
this,
offense.
this is what I have. Add parents or guardians to face mask medical exemption request form directly related to this order and direct staff to create the resolution.
Yes.
So just for clarity, because I think there's a lot of questions running around. We're following the mandate. We're following Johnson County Health Order. And what we're doing is modifying a form to allow
You are
to,
essentially establishing the criteria under which the district is going to accept a certification of a medical condition, health condition, or disability that prevents wearing a face mask covering. That's essentially what you're doing, which is not a, it could be argued to be a departure from the order, but I think it's within the discretion given to you by the order, is the way I.
Yeah, because
read this.
they didn't say who had to give the exemption.
And I
They
think
just
I
said
think they even
that it's
said,
for medical reasons or mental health reasons or whatever. So they didn't say who, they just said, what is the exemption? So that's what we're asking medical professionals and or parents to give us.
yeah, and I'm trying to read the order here. Computers.
It's 2A. Greg. It's
Yeah, no, I know what 2A says, but I thought there was another part that said something about the board being able to.
Okay, so a question I have is what about, and that is coming through, what about this applies to the students? Well, it just says parents can sign off on it. What about staff, especially that you're going to have people that ask if they've been vaccinated.
Yeah, I mean, you're only dealing with the opt-out and what you're doing, you're only dealing with students.
Yeah.
The order would still apply to anybody else in the building.
Yes.
So teachers, visitors, administrators, parents would be required to wear masks. Yeah, I don't see what I was looking for quickly, but I still think that what you're doing is you're setting the criteria for what you will accept in terms of documentation. I think that the order at least doesn't speak to that. So I think you've got the power to decide that without violating the order.
And this is simply just in our buildings.
Right.
K-12 buildings.
About the bus thing.
Yeah, it doesn't
Yeah,
deal with the bus. The bus thing's separate. We all understand.
Yeah.
That's a
That's
federal
required.
mandate, so that's different. That's totally separate, correct?
Right.
I started to say that's something that we'll have to put in the form because we've been allowing parents that if they fill this out, that it affects the bus as well. So we'll have to put a note in here that says this does not apply to the bus.
But the bus is a federal mandate. We can't.
K-12 buildings only.
Unless they had.
Yeah, unless the feds change it.
Maybe we'll just put a note in there that says, if the signature is by a parent, then it does not apply for the bus.
Right, because it could be that they still do have a medical exemption from a physician
Right,
for the bus.
right.
There's been some of those turned in.
I feel like that the parents will still think that that's an okay compromise too. I mean, I don't think anybody's gonna argue about that,
Yeah,
as long as they
I
don't,
don't see that.
as long as they can have the choice if their child is masked all day long or not.
I'll second the motion.
And then can I ask a question? The resolution then will, we are still going with the mandate, but we're allowing the parents to opt out. The resolution is that we are then not on Monday then? Is that what you're saying, Doug?
The what?
The resolution, when we put the resolution in place.
The resolution essentially certifies or
Support.
The resolution
we call
says,
out the law that we're going to ask to
Yeah.
be supportive of the exemptions.
Yeah,
Greg
basically,
can go defend if
yeah,
necessary.
basically what the resolution does is two things. One, it provides factual and legal support in a document that is called a resolution that would then bring that separate statute into effect that gives you broader power than your regular authority. So it gives me a better way to defend against any action taken by the board.
so the resolution folds it under limited home rule. Is that?
Yeah, basically.
It does what? What did you say, Doug? It does what?
We're using the statute that provides limited home rule
For the resolution, yeah,
I
for the
gotcha.
resolution.
correct.
And just to be clear, we're only talking about the mask, right?
Right.
Well, because our recommendations that we agreed to, that's the only thing in there that changed from the recommendations was the masks. Everything else is still in place. We still talked about only quarantining the people that are positive or exposed plus symptomatic. We talked about no other mitigation and like recess is open, all of that going back to normal, correct? So-
Right. I'm just trying to be clear because there may be somebody that's out there listening in that thinks you're doing a resolution to completely get away and to avoid the mandate. This is only for the mask.
Right.
Children.
And,
It's only
and
for exemption of the masks, right?
For students.
For students.
so really what's still in place from July 26th is all of the recommendations that you brought to us. And the only difference in there is that we had said optional masking, the county came out and said a mandate, and now we're saying that the parents can opt out of the mandate. That's it in a
No,
nutshell
we're saying parents can opt out of
of the mask.
wearing the
exemption.
masks
Their children.
Just their children.
with their
Children.
children.
The adults.
But what you're actually saying,
See, this-
hold on, what you're actually saying is not that the parents can opt out. You're saying that the parents can certify the medical, mental health, or other conditions necessary.
They can provide the
You're
exemption.
not, you're not, you're not giving parents the option to opt out. You're giving parents the ability to certify their child's medical condition for purposes of fitting under the exception.
So that kind of specificity needs to be in this motion. That's my
It's certainly
opinion.
going to be in the resolution.
Well, it says right now that blah, 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 documentation from a healthcare provider, the MD, DO, DC, PA, NP, psychologist, or parent or guardian certifying a qualifying condition must be provided. So that's already put in, that's already in here. So they're certifying that a qualifying condition exists.
Right. Yeah. That, what you're doing is you're allowing a parent to certify that.
But Greg, if I understand, we're still saying the parent is certifying this condition, correct? Okay.
Which is what allows the child to not have to wear the mask. Mental health is, and I don't have it pulled up. Give me a second.
What's it?
Is the condition have to be written on the form? There is a condition written on the form.
Yes.
Yeah, I mean, I think what it said. Why my computer so slow?
It does say condition preventing mask wearing.
Mental health is a pretty.
Yeah,
broad
they can
term.
write
Says-
mental health.
It says medical condition, mental health condition or disability that prevents wearing a face covering. So the person would be certifying that. I don't think you need to have the second sentence. No, although you could put it in there if you wanted to. I don't know what you got in the form. I'm sure the form's fine, but basically you're just adding the parent as somebody who can sign off on the form.
So if a parent is concerned about a child's mental health, they would write mental health there.
So read the motion again.
Add parent or guardians to face mask exemption request form directly related to this order and direct staff to create resolution.
Okay, so we just had a conversation around some pretty specific language, and I don't hear that in that.
I think the form already has the language in it, so the form would be incorporated into the motion. My suggestion would be that the form be added by the clerk to the minutes with the motion.
Okay.
I think that's, I mean, you want to agree, it needs to be specific, but I think that you could do that by specifically, the form specifically referenced by name. I think somebody added that a minute ago. So you want to make sure that that actual document is included with the minutes with the motion.
We'll make changes and then put this document.
And then, so how would this motion, if approved, impact the 16 things you outlined that had potential impacts to our staff?
I think that, I don't know. But my sense is that it changes the way you would look at those to some degree, because you would be looking at whether or not the districts, who the district is, or how the district is interpreting the certification process for whether a person has one of the conditions that allows them to opt out from the mask is something that would violate the order in any way, shape, or form. And here was where I sort of circle back to the district sort of authority in the absence of the order. In the absence of the order, you've got authority to do what you want to do in the school buildings. The order at best is, as I read it, is silent on what person could or could not certify those conditions. So I think the district is probably within its authority to make that determination. So I think that somebody following that would not be violating the public health order as written, or you've got to make a couple leaps to get there. So I think it's less likely that those consequences would be in place. Some of the other stuff, I don't know, but that's my quick thought is that it's still that's an area I think that was left open enough for the board to have authority without violating the order. Whether that means you're violating the order in spirit or not, I don't know, but that's not, you'd have to be an actual proved violation of the order for any of those consequences to come into effect, with the possible exception of somebody using the sort of loosened mask exemption as a basis for some liability or negligence, which, again, that would all fall within under the Tort Claims Act and be fairly hard for somebody to prove.
Greg, would you say that this would provide some cover to teachers and principals, as they're not the ones determining the certification, but just this would be a person that would be exempt, so they wouldn't have to enforce it with? Would that provide any protection to those individuals?
I think arguably it would. I'd have to think it through a little more carefully, and certainly would want to increase that. Take a look at that as we're putting the resolution together. I mean,
It would appear that would be on the back of the parent that signed it, in my opinion.
Right.
yeah, I mean, your issue. The only thing I can think of, just to throw it out there, is your issue might not be with the parent who signed it saying, my kid doesn't have to wear a mask. Your issue might be with a parent whose kid wears a mask and nonetheless contracts it from somebody who isn't wearing a mask based upon the release. That's about the only thing I can think of right now. And again, I'm just sitting here trying to think on the spot, so I don't want to say that that's like anything definitive. And a lot of this stuff, as I said from the beginning, I'm not telling you any of this stuff is going to happen. I'm just trying to worst case scenario plan this stuff out so you guys at least have thought about it. But that's about the only thing I could think of, is not the kid whose parent signs the certification and says my kid doesn't have to wear a mask because of their medical condition. I think that parent's ability to come back after the school district is going to be pretty low. It would be the other kid in the classroom whose parent didn't sign a certification or who didn't have a release from a mask obligation, who could potentially trace through contact tracing or otherwise trace their kids contracting the illness to somebody that's there without a mask. That there's so many things that have to establish to get there, but that's about the only thing I can think of.
Doug, could you run back through a few of those on your major points on your list? You said you had how many? 16.
Well, first was KSB had an opinion that says we can't use home rule to eliminate the mandate. So it's the whole mandate, I think, is what they were referring to. Is that right, Greg?
Yeah, I think that's what they were referring to. They didn't specify otherwise, so I assume that's what they're saying.
Second is that regardless of what a sheriff or an attorney or whoever wants to tell you, and verbally, it really doesn't mean anything, that they can change their mind
Of course, I agree with that.
however they want to.
Trust that at all.
Right, so talk isn't binding is what I wrote down. There's statutes on the books that talk about penalties, right? That there's a whole litany of statutes that come into this health order, I think, that are probably statutes referencing statutes, right? So that they have to pull that full order. The resolution to eliminate the mandate would not negate the county's health order, right? It's still there. Both would be in effect. and the court would have to decide. Another one was, Mr. Goheen mentioned that why a court might lean towards the school district for educational impacts. They're going to lean most likely towards the county for health and safety, because that's, as the Board of Health, that's their purview, that's their
And I think allowing parents to sign off on their child's health impacts, I think that goes right along with that personally.
with the education, leaning towards the
Well,
educational.
just saying that a parent knows better the health of their child than somebody in the
Yeah.
they would health department.
Yeah, and so the court would say they agree with that for the individual student. Their responsibility is for the community. I think that's the flip side of that argument. Talk to what a risk was a resolution that has strong facts and support, has to have fact-based rationale. Talked about the insurances. Mr. Goheen talked about, I had written down something about both policies limited by Tort Claims Act. Says our insurance provider said, I think you said they said follow the order, but there was immunity because there's immunity within the order.
Yeah, they did.
General liability, there's a potential issue with an exclusion for infectious disease. Error and omission policy applies to board action except there's potential, except for potential violations of the law. And that's where the thought about OSHA coming in. How would OSHA and disease play into that? That was an unknown, but it's a potential concern. Consequences, Mr. Goheen mentioned facing an injunction, county or outside the county could seek closure of the school, because the county has the authority. I talked about school officials, civil, criminal, and licensure issues. This is very concerning to me about, and I want to know about how this changing the signature. We have amazing teachers in our organization. We have amazing administrators, and I'm not willing to make a decision that or vote in a way that might in any way, shape, or form put their licensure at risk. I'm not willing to make that decision for them. If they want to do something on their own that's going to put their licensure at risk, that's their decision. I'm not willing to make that decision on their behalf because I think it's up to them. School officials, including the board, administration, civil, criminal, licensure. Again, that was the same thing. The 12th was, there's just this nebulous thing about other applicable statutes, I think, within the health order that you mentioned, which anytime there's the caveat that we can pull in any kind of statute ever laid out there, I think that's a concern. Talked about a public health order. If we're not following it, someone gets COVID. They would have to prove that they got it in the school, but the potential, the risk, the issue is potentially a felony charge against someone. And I don't know who that would be towards, but that sounds like that caught my ear. Code of conduct, safety of a child, neglect and health and safety. Can someone come in and if you don't follow the order, can someone come in and say, hey, you've neglected my child because they've suffered some kind of you've departed from the order, and they've suffered something from that. Now there was claims of students about there's a policy of a health order that if we didn't follow, they could claim negligence on our part. And then finally, I think, this is, if you didn't follow that mandate, if we didn't follow that mandate, I just heard dollar signs rolling up. When we talk about all the litigation, we talk about all the court hearings, we talk about the, just all of the legal costs in a year that we know is going to be very, very challenging from a budget perspective. Is that an accurate statement, Dr. Byrne? That it's going to be challenging this year as far as budgets go. And so I would have a very hard time voting for something that's going to take resources that directly educate our students away from them to play in a power game with the county. I have a real problem with that, with removing those resources. Our administration, our teachers, our staff do an amazing job with the resources that we provide them. They magnify everything. You give them $1, they give you $10 back worth of value. And I think we need to respect that. And I think we need to continue to support that. So those, to answer your, it's a long-winded question, Brent, but
You got it.
those were some of the things that caught my eyes as potential issues. If there's one or two, I think that's one conversation. When there's 16, I think it's an entirely different conversation. So
The good
it
news is,
sounds
though,
like
you're
what
not
we're
saying-
doing is, it would sound like what we're doing is we're still going to follow the health order, which I think your on the spot opinion, Mr. Cohen, was that would temper and reduce the potential negative impacts to our employees of the district.
Yeah, I think that's fair.
They'll pull a couple things out of it
Mhm.
that you said. Since we are not choosing to not follow the mandate.
I
didn't
got
say that
lost
right.
in the double
Since,
negative
yeah,
there, but
since we're choosing not
we're
to
choosing
follow,
to
okay, I
follow
get it
that.
backwards. Anyway, I'm tired.
We're remaining silent on whether we're following or not, so it means we're following.
Yes, and
Right.
technically that we could argue that we would have immunity through their carrot.
You could argue that.
We're following it. So you promised us immunity if we follow you, we're following you. And the other thing, talking about OSHA, I don't think OSHA would want anything to do with this. We could come right back at them and said, you didn't tell us to wear an OSHA approved mask. When you say that, then I think that conversation's over.
And they used to say that you could only wear it for 15 minutes or an hour or something.
I think OSHA would have a serious problem with a bandana
Yes, that's what I'm saying. That, so that I'm throwing OSHA out as well.
Or silk,
or a towel
Yeah.
or just holding up your t-shirt.
linen.
All right. Any other discussion?
You have a motion on the floor.
Yep, we're in the discussion, Candy.
After we go through the vote, well, I mean, I can do it now. I would still like to at least possibly, if the board would like to file a complaint against the Board of County Commissioners for imposing this order on us in violation of Kansas statute. At least it gets the complaint in their hands. They can do with it what they want. And then if they don't take any action, then we can do whatever we want after that. So I think just filing a complaint would at least get their attention.
So it's
Is that a
interesting
separate
how
motion?
Yeah, but are we sure we want to get their attention?
it's
Well, I mean,
interesting.
that's why I said if it's the
Sometimes you
appetite
don't
of the
poke
board to do
bear
that.
either.
But so I'd rather do the vote and then I'd like to discuss that.
Further discussion.
Sometimes you poke the bear
Yep,
bites.
I know.
So I think it's interesting what happens over
Already
time.
hooked the bear.
Last year at this time, we were begging the county to make a decision and impose it. That's what the reality
Sure,
was. We were saying, why are you telling us to create gating criteria? We wanted them to make the decision and impose it. This year they did that. And we said, no, wait a minute. We don't want you to make
Do
a
it to
decision.
us.
Right.
Well, there's a big piece missing in there. We also mid-year, January, said this is not working for our district, and we voted to not follow what the county
Mhm.
had put in place.
So up until that point, I remember conversations in our board meetings.
Yeah.
Where we said, this is not right. They should have done this and not rolled it down to us. And now they roll it down. They make a decision, do that. And and that's what time does, right? That's what water under the bridge does. So,
Well, right, with more information and, with COVID in general, everything is like
Yeah.
evolving all the time. So we're evolving with it, with
Sure.
information.
so
Call
there's
for a
a,
vote, though. Just go ahead and vote, and then we can
let's call
discuss
the
it.
motion.
Yep.
I just did. Katie, please collect the vote.
Mr. Updike,
No.
Mrs. Mitchell,
Yes.
Mr. Anderson,
Yes.
Mrs. Sealing,
Yes.
Mr. Hoffman,
Yes.
Mr. Winbolt.
Yes.
Approved.
We're adjourned. Unless you want to move. You want to
No,
move and add
we can-
something to it?
What, I would,
You'd have to move to add.
Yeah. can we add that to a discussion item for Monday?
Sure.
The filing a complaint with the county,
Yes.
Board of County Commissioners. Yep.
We're adjourned.
Thank you.
Special meeting.